President Trump is big mad at Harvard. I mean, I am too, but for very different reasons. But in retribution for fighting back against the administration, President Trump is trying to prevent any international students from studying at Harvard. But hours after he tried to prevent Harvard from enrolling or continue to enroll international students, a judge stepped in and enjoined it, at least temporarily. Yes, President Trump and DHS Secretary Kristi Noem thought they could deport every international student and teacher at Harvard. But Harvard's conservative lawyers, led by Trump fighters Jenner and Block, marched into court early Friday morning, and a federal district court judge shot down the government's policy before Trump and Noem even had a chance to finish their morning coffee. This one might take the cake as the fastest injunction against the Trump administration, being issued just mere business hours after the initial complaint had been filed. As you may know, President Trump has been targeting Harvard ever since the university openly defied his demands to limit pro-Palestinian activism and end diversity, equity, and inclusion practices. But now Secretary Noem alleges that foreign students and teachers have turned Harvard into a den of anti-Semitism and communism. So she purportedly revoked Harvard University's certification under the Student and Exchange Visitor Program, which I'm just going to call CVIP for short, which is the program which allows universities to admit international students. And although the administration claims that their actions are motivated by students who are Hamas sympathizers, whatever that means, the policy makes no such distinctions. So today we're going to delve into Trump's attack on Harvard's foreign students and explain why a district court quickly put a stop to it. Now, for over 70 years, Harvard has hosted international students under the F1 and J1 visa programs. The F1 visa is for international students, and the J1 visa is for teachers and researchers. Now, to maintain their certification, schools have to adhere to strict record-keeping, reporting, and compliance requirements, and students have to remain enrolled in school full-time to stay in status. But on April 16, 2025, DHS Secretary Kristi Noem sent a records request to Harvard, citing Harvard's alleged failure to condemn anti-Semitism and implying a hostile campus environment. The request demanded broad and vague data about every international student, including whether they had engaged in, quote, illegal activity, made threats, or obstructed the learning environment. Now, Noem's request did not define any of these terms. But according to Harvard's complaint, quote, over the last 12 years, Harvard had received only a handful of requests for information about its F1 visa students. These requests have generally sought straightforward information plainly contemplated by the applicable regulations, such as the student's email, physical address, and phone number about a single student at a time. No prior request has asked for information as broad or as open-ended or covering as many students as the records request. Now, DHS gave Harvard a laughably short 10 business days to comply, threatening that their failure would be treated as, quote, voluntary withdrawal from the F1 program with no appeal allowed. Now, despite the unprecedented scope of the letter, Harvard claims that they complied with the request. On April 30th, Harvard submitted the records outlined by 8 CFR 214.3, including records of coursework and academic transcripts. And on May 14th, it submitted additional information in response to a follow-up request. And in its response letter, Harvard asked the government for the opportunity to cure any alleged non-compliance. And the university contends that DHS cannot unilaterally revoke its CVIP certification without allowing it a chance to address the government's concerns. Now, when Harvard filed its lawsuit, its complaint cites 5 U.S.C. 558C, which states that before revoking a license, the government must give the licensee, quote, notice of the facts or conduct which may warrant the action and an opportunity to demonstrate or achieve compliance with all lawful requirements. Nevertheless, on May 22nd, DHS revoked Harvard's CVIP certification, calling its responses insufficient, without providing justification or citing any specific regulation that Harvard violated. Now, Harvard alleges that DHS failed to, quote, follow any of the detailed processes required under the regulations prior to revoking a school certification. And the lawsuit brings 3 claims against the government. First, Harvard claims that the government violated the First Amendment by retaliating against the university after Harvard refused to adopt the political directives and suppress certain viewpoints. Harvard alleges the government explicitly tied its punitive actions to Harvard's speech and refusal to follow Trump's ideological mandates, such as conducting viewpoint audits and disciplining specific student groups. Now, the second claim is for violating the Fifth Amendment's right to due process. Harvard argues it was denied notice and an opportunity to contest the CVIP revocation, violating procedural due process. DHS allegedly skipped the entire regulatory process outlined in 8 CFR 214.3 and 214.4, which required notice, a formal review, and an opportunity to respond. And the third claim is for violations of the Administrative Procedure Act. Harvard asserts that DHS failed to follow mandatory procedures and did not identify any lawful basis or specific regulatory violation to justify revoking its certification. The government's decision to revoke Harvard's certification was arbitrary, capricious, and unsupported by a reasoned explanation. Now, if you tried to ban international students from a university, you'd probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you've got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. And it may not surprise you that all three of these claims appear to be very strong at first blush. But let's look at how the First Amendment actually operates in higher education. Do they have a leg to stand on? Now, the First Amendment protects individuals from government interference in freedom of speech, religion, press, assembly, and petition. However, it only restricts government actors. That means that Harvard, as a private institution, generally is not directly bound by the First Amendment in the same way that a public university like the University of California is. If Harvard wanted to implement all kinds of restrictions on speech, it probably could. Harvard itself enjoys robust First Amendment protections. That means that Harvard can speak as an institution, take positions on issues, and curate academic environments without government interference, generally speaking. And a school can also generally decide on who to admit, hire, or associate with, as long as it follows anti-discrimination laws. And the Supreme Court interprets the First Amendment to protect academic freedom of institutions and faculty, especially in contexts like scholarly research and teaching. The Supreme Court has held that academic freedom is a, quote, special concern of the First Amendment, and the first major recognition of academic freedom as a First Amendment concern came in the 1957 case of Sweezy versus New Hampshire. Paul Sweezy was an academic and Marxist economist, and during the Red Scare, New Hampshire passed a law empowering the state attorney general to investigate subversive persons. Now, the AG subpoenaed Sweezy to testify about the content of his lectures and political affiliations, and Sweezy testified that he was not a Communist Party member and did not want to overthrow the government. However, he refused to answer other questions, such as his personal beliefs about communism, his knowledge of the Progressive Party in New Hampshire and its members, and the content of his lectures. But the state claimed that during a lecture he described, quote, socialism as inevitable in this country, and they asked him if he believed in the theory of dialectical materialism, because people always forget the connection between Hegel and Marx, and whether he advocated Marxism to his students. And when Sweezy refused to answer, he was held in contempt of court. Now, appeals courts upheld his conviction, but the Supreme Court overturned it. The plurality decision struck down the application of the state's Subversive Activities Act because it was overly broad. Then in 1967, the Supreme Court struck down loyalty oaths for public school teachers in Keishian versus Board of Regents. In that case, as a condition of employment, New York state laws required teachers to sign loyalty oaths to refrain from, quote, treasonable or seditious speech or acts. All employees had to certify that they weren't members of the Communist Party. The plaintiff and his colleagues refused to sign the loyalty pledge, and their contracts were terminated. The Supreme Court reversed in favor of Keishian on the basis that the statutes were unconstitutionally vague and overbroad. And the court held that the New York laws had a stifling effect on the, quote, free play of the spirit which all teachers ought especially to cultivate and practice. The majority said, quote, our nation is deeply committed to safeguarding academic freedom, which is of transcendent value to all of us, and not merely to the teachers concerned. That freedom is therefore a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom. The vigilant protection of constitutional freedoms is nowhere more vital than the community of American schools. The classroom is particularly the marketplace of ideas. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas which discovers truth out of a multitude of tongues rather than through any kind of authoritative selection. And that probably gives you an idea of why Harvard's lawsuit frames its First Amendment claims in the context of academic freedom. The complaint states that, quote, Harvard has long exercised its academic freedom by determining for itself on academic grounds who may teach and what they teach. And Harvard alleges that, quote, the revocation is a blatant violation of the First Amendment, the Due Process Clause, and the Administrative Procedure Act. And Harvard went out of its way in compiling evidence that the administration is retaliating against it for refusing the government's demands. On April 11th, the Trump administration sent a letter to the university seeking full control over Harvard's curricula. Quote, the government demanded, among other things, that Harvard hire a third party to audit the viewpoints of its students, faculty, and staff. Depending on the results of the audit, hire and admit a critical mass of people to achieve the government's preferred level of viewpoint diversity in each department, field, or teaching unit, refuse admission to international students hostile to American values, exclusively empower faculty supportive of the government's action and reduce the power of those opposed, allow the government to review its faculty hires, expel or suspend specific sets of students, disband disfavored student clubs, establish mechanisms for Harvard community members to report on one another and send those reports to the government, which, yeah, seems like an all-out assault on Harvard's First Amendment rights. Then on April 14th, Harvard refused the government's demands, and just hours later, the Trump administration retaliated by freezing more than $2.2 billion in research funding. On April 15th, Trump posted about revoking Harvard's tax-exempt status. Then on April 16th, Noam sent her letter demanding detailed information on all foreign students, and the government issued a press release explaining that Harvard had, quote, allowed anti-American pro-Hamas ideology to poison its campus and classrooms and undermine America's values. On April 24th, Trump's newly weaponized EEOC announced it was investigating Harvard's hiring practices, and on May 13th, the Department of Justice issued a civil investigative demand to the university for allegedly violating the False Claims Act by continuing to maintain affirmative action programs struck down by the Supreme Court. Quote, The surrounding events and defendants' express statements make clear that DHS took these actions not for any valid reason, but purely as punishment for Harvard's speech, its perceived viewpoint, and its refusal to surrender its academic independence or relinquish its constitutional rights. A central tenet of our constitutional system is that the government cannot invoke legal sanctions and other means of coercion to micromanage private speech. And it is bedrock law that the viewpoint-based justifications the government has repeatedly and publicly invoked as a basis for its campaign against Harvard are a particularly egregious form of content discrimination, subject to the strictest scrutiny. The government's actions violate Harvard's rights under the First Amendment several times over. So mere hours after Harvard filed its lawsuit, which itself was only mere hours after the government revoked its certification, Harvard filed a motion for a temporary restraining order asking the court to vacate DHS's revocation of its CVIP certification, enjoin DHS from enforcing the decertification, and restore its ability to enroll and host international students under the F1 and J1 visa programs. Harvard argued that the revocation inflicted serious harm by immediately stripping legal visa status from over 5,000 students, and it arguably barred new students from enrolling for the summer and fall terms. It also dealt a blow to Harvard's finances since most foreign students pay full tuition, which winds up subsidizing American students. And the revocation would also hurt the school's ability to recruit international talent. And surprising no one, the Massachusetts District Court immediately granted the motion. The judge's order enjoins the administration from, quote, implementing, instituting, maintaining, or giving effect to the revocation of plaintiff's CVIP certification, giving any force or effect to the Department of Homeland Security's May 22, 2025 revocation notice, and the court set a preliminary injunction hearing for May 29th. So Harvard's international students are safe for now. Still, if you're an aspiring Harvard student, it might be a good idea to scrub your online presence, which is why online privacy is so important. Luckily, there are people out there who can help, like today's sponsor, Incogni. And use my link in the description or the code LegalEagle for an exclusive 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too because Incogni fights back. And Incogni just launched a new feature called Custom Removals for subscribers to their unlimited plan that I think is really great. It allows you to flag an unlimited number of sites where your data is exposed, and you can have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. Because these data brokers are the reason why in the US you can search your name and find a bunch of websites that'll give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours or weeks. So thank you, Incogni, for saving me all that time and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. And Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. And if you click on the link that's on screen right now or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you do decide to keep it, you'll still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word, at checkout. So after you sign up for Incogni, click over here for more LegalEagle, or I'll see you in court.